අයියේ මේ ගෙවිඳුට මේ ගෙවිඳු පිට දුව ගමගේ කෙනෙක් කෙනාට හොස් දෙනවද?
right මාව ඇහෙනව නේද? guys මාව ඇහෙනව නේද? පොඩ්ඩක් කන්ෆර්ම් කරන්න.
Hello. Yes, we can hear you.
All right, right, okay. So I think we were discussing about sorry for that small interruption, but we were discussing about um, how a consideration has to move from the promisee, right? So this is the first rule. So this comes from the doctrine of privity, as I was saying, right? Which basically means that uh, the contract should always lie between the parties of the contract at all times, right? So there's like this, there's sort of a scope of a contract which is formed between the parties. No one else can, of course, come in unless through consideration, right? So for a person to be a party of a contract, he is required to provide consideration, right? Like I mentioned earlier, uh, for a promise to be a contract, it should entail a certain amount of consideration, right? Similarly, for parties of a contract, uh, to be considered as valid parties or parties who are able to enforce a contract, they should provide consideration as well, right? So that's called the doctrine of privity. So this rule goes with that, right? So for a person to take action in a contract, or let's say through a contract, they should show that the consideration moved from them, right? And not from anyone else, right? So the best case we can use for this is called Price versus Easton. Um, so in this case, what happened was basically one person was in debt to another person, basically, and he agreed to work for someone, and by working for that person, he would earn some money. Let's say A and B, right? A, B, and C, right? So now B was in debt uh, to C, right? And B decided to work for A and earn some money, and this money would be then transferred to C to basically nullify his debt, right? Or basically to cut off his debt, right? Um, but though B worked for A decided not to pay B, right? Uh, B for whatever the work he did. But then C, right? C being a party out of the contract. Now the contract was formed between A and B, right? B was working for A and A promised to pay B, right? But the money, of course, was to go to C, right? Because B was in debt to C. Um, but C was not part of the contract, right? He was outside of the contract, right? He was a stranger to the contract. We call those people strangers to the contract, right? They are outside of the contract, right? So when A decided not to pay, C, being a stranger to the contract, went and filed action, right? But then the court held that though B performed the contract, C was not capable of filing action against A because he was not part of the contract, right? So he cannot sort of file action because he is not part of the contract, right? So that would basically nullify a person from filing action if he's not part of the contract, right? If he's not a party in the contract. Of course, he could be a participatory body, right? Now, in that contract that was formed, the money in the end was to go to C. But that doesn't necessarily mean that C is part of the contract. Why? Because he didn't provide any consideration. He was not part of that contract. He didn't work for A. Neither did A gain any benefit from C, right? So because of that, C was never part of the contract. And since the contract was not, since C filed action, the court held that he was a stranger and therefore action could not be filed. So that was the case of Price versus Easton. A very similar case was found in the case of Tweddle versus Atkinson. So in this case, basically, the two fathers of a bride and a groom had agreed to contribute with some money to the for the future of the bride and groom, right? Once they get married. But before this contract was, or before this money was basically passed, one of the fathers, the father of the bride died, right? So the father of the bride died, and then later, before before the other father could have sued for this money, he also died. Right? The other father, the father of the groom, also died. So when this happened, the groom brought in an action. The groom is basically the husband in that marriage, right? Brought in an action to basically recover this money. But then the court held that the groom was never part of this agreement, right? Why? Because this agreement was formed between the two fathers, not between the groom or the bride or the groom and the other father, right? So because of that, he was again a stranger to this contract, and therefore he had no right to sue any party with regards to this contract because he didn't pass any consideration, right? Yes, he was part of the contract as a participant, right? Why? Because he's given the consideration in the end. The two fathers collect the money and give it to the bride and the groom. But that doesn't necessarily mean that the bride and the groom are definite parties of the contract because they didn't pass any consideration, right? They do get a benefit out of it, right? The fathers give them money, they get the money, that's a benefit for them. But then do the fathers get a benefit? No, right? So because of that, there is no consideration between those parties. And because of that, you can't file action for a contract where you're not a party and where you're a stranger to that contract, right? And the court further affirmed this, right? They basically affirmed the judgment in the Price versus Easton here, in Tweddle versus Atkinson, right? So the first rule in that sense is basically that the consideration should be passed or should be supplied by the parties of the contract, right? And for parties to become part of a contract, they have to provide consideration. That's the basic rule, right? You can imply it. Now, when you say parties, the rule is basically that consideration should only come from the parties of the contract, right? Which means that for a party to be part of that contract, he has to provide consideration, right? So that's the basic rule, right? For parties to be considered as part of a contract, they have to provide consideration to that contract, right? So that's the first rule. Then the second rule is that consideration should not be in the past. Now, consideration could be, like I said, it could be a benefit, it could be a right, it could be bought in through an action or whatever, right? Now, this consideration in English law, this is like a specific rule to English law. In English law, past consideration is not considered as valid, right? Past consideration, which means that if something was done in the past, and if you were to create a contract to pay for that, then that consideration is not valid, right? So this is basically a principle of English law, right? Past consideration is not a valid contract. The best case is the McCardle case. So in this case, what happened was basically the father of 5 children had left his house with life interest to his wife, basically, right? So now the father had 5 children, right? And he had left the house for his 5 children, right, with equal shares, right? They have equal rights to the house. But one of the wives of the sons, now there were 5 children, right? But one of the wives of the sons, right, one son's wife, basically decided to carry out improvements or basically refurbish the house, right? Now, one person took responsibility and went ahead and refurbished the house. And she had borne all the costs for this refurbishment, right? But, like, obviously, she had borne costs, like, she had paid from her own pocket, right? Which obviously had costed around 500 sterling pounds at the time, right? Now, then later on, the 5 children, since there's 5 children involved in this, who are owners or who have rights to this house, they had decided to, they had promised to repay or reimburse, basically reimburse the money that she had spent, right? The money she had pocketed from her by herself. The 5 children had decided to repay that money or reimburse it, right? Uh, but that was of course a promise, right? They just promised that they would reimburse it, but later obviously they didn't, right? And then this lady had filed for action requesting for this money to be paid. But then the court held that the work here, basically the task here, was basically the refurbishment, right? This refurbishment and the improvements were done before this promise was made, right? It was something that was done before the promise was made, right? So it's in the past, right? So that's past consideration. Now, why do you pay her money? Because she did the refurbishment. But the refurbishment, being part of the consideration, happened before the promise was made. So it's in the past, right? Now, let's say, for an example, let's say this refurbishment happened on the 1st of December, but then these children came to an agreement that they would pay her on the 10th of December, right? Now, the refurbishments happened before the agreement was formed or before the promise was made, right? Which means the consideration there was in the past. As a result, it's not considered as good consideration or valid consideration, right? So hence the agreement was not enforced. Now, if a consideration is not passed, what happens is an agreement will not become a contract, right? A contract is something that is enforceable. And if there is no consideration, that contract is not enforceable. Then in this case, because it was past consideration, the agreement was not enforceable, right? Yeah, and a similar case, this is from Sri Lanka. Now, this case was from UK, the earlier case I mentioned. Salman versus Obias is from Sri Lanka. This is a Sri Lankan case. So in this case, what happened was basically a person had looked after his grandmother, right, and had obviously borne certain expenditure for her medicine and stuff, and because of that, the grandmother had decided to transfer the property she was living in to this person, right? Why? Because he had provided due care and also given her medical treatment, provided her with medicine and all of that, right? But now this this action of this looking after the grandmother and obviously providing medicine and all happened before this contract was made or this transfer, right? So the transfer of the property was made considering that obviously the part where she was taken care of, and then obviously where she was provided medicine, where all the expenditure related to her medicine and all of that were borne by this person, was considered as the consideration of this particular transaction, right? But the transaction happened later, right? Transaction happened on a later day, considering something that had happened in the past, right? Again, it was considered as past consideration, and therefore the contract was not enforceable, right? So these are basically two of the basic scenarios where it's non-enforceable. But there are also exceptions to this. So an exception, in the sense, what I meant was, though if something is a past consideration, under certain scenarios, the past consideration can also be enforceable. Right? There are certain scenarios like that. The best example is so the first exception is when there was a previous request made by the promisor. Now let's say if someone does something, right, and then let's say again A and B, right? So A decides to A asks B, let's say, to go uh, to let's say A asks B to take care of his mother, right? So B had gone and taken care of the mother and provided medicine and all of that. But then later, A had told B that for obviously for this action that he had done, he would pay B, right? Uh, Now again, by the time he had promised to pay, this this action was completed, right? The mother was taken care of, all of that was done. But so because of that, it becomes past consideration, right? The action was made before the promise, right? Past consideration. But this action was done at the request of A, right? A had requested B to go and take care of the mother. If not, B wouldn't have gone and done so, right? He wouldn't have gone and taken care of the mother, right? So if that's the case, if B had acted on the request of the promisor being A, then that would be considered as valid consideration, right? Though it's past consideration, it would still be considered as valid consideration. So the best example is the case of Lumpley versus Brathwaite. So in this case, what happened is Brathwaite had committed murder and he was obviously imprisoned, right? But then he had asked Lampley to get a pardon from the king, right? So similar to presidential pardon, right? The king can pardon offenders, right? So then Lampley basically had gone across the country. He had gone looking for the king, and he had borne costs, right? He had to travel by he had to sail by ships and all of that, and go and meet the king. So there was a certain cost that he had incurred, right? And he had somehow gotten Brathwaite a pardon, right? So later on, Brathwaite had said that in gratitude for what Lampley did, he would pay him 100 sterling pounds, right? Which he obviously failed to pay later on. So because of that, Lampley obviously filed action asking for this money. So again, the court in this instance uh, found that uh, Lampley had acted due to a request made by Brathwaite, right? So that in itself gives you an implied promise, right? So, like basically asking someone to do something, unless you say that you have to do it in goodwill, unless you say that please do this free of charge or something, you have an agreement at the start itself, you would definitely or that person would have definitely assumed that he would receive some money, right? Let's say now, for an example, in a company, let's say you ask someone to work, right? And that person would work knowing that he would obviously get a payment at the end of the month, right? So it's some sort of an action he does, but he would get paid at the end of the month, right? He does that with knowing that, right? So upon the request of someone, he works knowing that he would get money, right? So in that sort of a scenario, if you're working on the request of someone, there definitely is an implied promise that you would get paid, right? As a result, though it's in the past, though consideration was in the past, it was still to be considered as valid consideration, right? Is that part clear? That's a bit of a confusing area. If uh, anyone finding it difficult, you can ask, right? It's a bit of a difficult area. That's why I wanted to like emphasize on. Yeah. Okay, I'll continue. If y'all have any questions, just drop it on the chat box, right? Or y'all can, yeah, I think there's a question. Yeah, okay. So, yeah, thanks, Kasim. Yeah, so we'll continue, right? So the next scenario is a business scenario. So, in a business, right? Like I mentioned, like when it comes to employer and employee, right? Uh, you would normally expect the employer to pay you, right? When he requests you to do something, right? Let's say if let's say A is the employer and B is the employee, A had asked B to do some research, right? If it's like a research firm or something, he had asked B to do some research, right? Uh, so now B would definitely expect A to pay him, right? Because if you're a firm and if you're working as an employee, you wouldn't work for free, right? Unless you're like actually working for free, right? Unless you've come in with an agreement that you would work for free, right? You would expect him to pay, right? So there's an implied promise or there is a reasonable expectation for you to get paid, right? That expectation applies here. So though you have done something in the past, you would expect a person to pay you, the promisor to pay you, right? For whatever you do, right? So because of that, again, the consideration would be valid. So the best example is the Casey's patents case. So in this case, what happened was Casey was someone who had worked under Stewart and uh, Carlton. So he had basically done some documentation and all that. He had done some work for these two, and these two held a patent, right? And later, in return for his work, they had promised to give Casey one third of the interest of the patents, right? Because he had done a lot of work, right? For uh, but then later, obviously, they said no, right? This is again past consideration. That was their argument. But then the court said again, in a business context. Now, a patent is a business context, right? You give one third of the patent, that's a business environment, right? It's a business context, right? So, in a business context, you definitely have a reasonable expectation to be paid, right? If you do something, right? And when you make a promise, and then when you say no, when you make a promise, like obviously, even after something has been done, you make a promise that implies that you would be paid, right? It's fine. You can expect them to pay you because they've obviously asked you to work, and you could expect them to pay you. And also later on, they have given a certain amount as well. They've said, "I'll pay you one third for what you did," which again creates a binding contract. Why? Because though it's in the past, you would have expected someone to pay, right, for whatever you did, right? You wouldn't be doing it free of charge, right? In a business context, right? So in that sort of a situation, once again, uh, this exception gives effect, right? So you all can read this case also. This is also a very similar case to that. Again, if something was done again in a business context, same scenario, right? So then the third rule is that consideration should not be vague, right? Now, when it comes to consideration, it should be properly defined in a contract, right? Now, let's say if you're buying a car, you have to say, okay, this car, this particular vehicle, right? This vehicle bearing the number plate number, bearing registration number, this, and it should be specified, right? Which would be purchased for a valuable consideration of 2 million, right? Same in like deeds of transfers as well. This said land name this situated here. Lot 1, lot 2, you have to specify properly. It should be definite and precise. It should be very clear, right? So you can't necessarily say, okay, this land, a part of this land will be given, right? We agree to provide part of this land. Now, when you say part of the land, what's the part, right? So that's very uncertain. It's very vague, right? Consideration cannot be vague. It should be specific. Okay, if it's a 4 lot land, if a land is divided into 4 parts, you should specify, okay, lot 1 of the land, lot 2 of the land, lot 3, or all 4 lots of the land, right? You have to specify. So consideration in that sense cannot be vague, right? It should be definite, right? So that's a very important very important fact that has to be established. That's a rule in consideration because it's 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 an important part, right? If that part is vague, then the contract itself is vague, and therefore the contract is non-enforceable, right? So the definition of a consideration should not be vague, right? It should be very clear, right? If it's let's say if it's cash, right? If it's a valuable consideration, 10,000 rupees, you can't just say 10,000. 10,000 could be dollars, 10,000 could be sterling pounds, right? 10,000 rupees, Sri Lankan rupees only, right? 100,000 Sri Lankan rupees only. $10 only, 10 United States dollars only, right? So you have to be very clear, right? So that's the third rule. And then the fourth rule, this is kind of, I guess, the most important rule under consideration. Most important, and also it's a very lengthy rule, right? This is like something that a lot of people find it difficult to understand. So I'll keep it a bit slow. If you all have any questions, just post it, right? So consideration need not be adequate. What they mean by this is a consideration must have a certain value. Now you can't give something which does not have a value, right? Let's say this value again, it doesn't necessarily have to be equal, right? Let's say one party gives $10 for something, the other party, let's say, had borne around $100 to do. If they had agreed to it, then that's fine, right? I mean, uh, it depends on just has to be a certain value, right? Let's say you take a you decide to give a wrapper, right? Let's say you eat a chocolate, and then two people had agreed that if you give 5 wrappers, you would get, let's say some sort of a toy in return, right? This normally happens in like these brands, right? If you send 5 wrappers in by mail, you would get a toy in return, right? Now that's the agreement, right? The toy is really expensive, right? The toy, let's say, is worth 10,000 or something, but the wrapper is nothing, right? The company would get it and throw it away, but still that's consideration, right? It's given such a certain level of value. This value doesn't necessarily have to be monetary, right? It doesn't have to be a value imposed by imposing digits, right? You can't just say, okay, this is worth 1 rupee, 2 rupee. That's not necessary, but it should have some sort of a value, right? Now you can't give something without any value. It should have some sort of a value to that contract, right? To that particular contract, right? So this doesn't necessarily have to be in monetary terms, but in some cases, yes. Valuable consideration. When you say valuable consideration, now, for an example, sales of goods ordinance, right? They expect valuable consideration, right, for goods to be exchanged, right? So when they say valuable consideration, then you have to give a price, right? Then you have to give a value. You have to give a monetary value, right? But if it's not valuable consideration, then of course it could be anything in the context of the contract, right? You can exchange anything, right, for that matter, right? So in some circumstances, though, like let's say now, like I said, if a consideration is of value, then it should be accepted, right? In the context of the contract, if there is a value, you can accept. But there are certain circumstances where the consideration becomes inadequate as well. And I'll give you a few examples, right? The first example is public duty. Now, if someone is bound by a public duty to do something, then if you agree to do that, that doesn't necessarily mean consideration, right? You have already agreed to do that, right? You're anyways bound to do that, right? And just because you agree to do that in a contract doesn't mean you have to be paid, right? Let's say for an example, um, by the law, you're expected to walk on the traffic or walk on the yellow crossing, right? On the traffic crossing, right? On the pedestrian crossing, right? And then let's say you agree with someone. Okay, someone says, okay, I'll pay you 200 if you walk on the crossing, right? Now you're already bound by the law to walk on the crossing, right? To only cross the road through the pedestrian crossing, right? Now, just because while you're under that contract, you can't necessarily say that you've borne a forbearance or there is a loss on your part by you fulfilling a public duty that you have, right? So by going on that, you can't necessarily ask for 200 because you're already bound by the law to do that, right? So in that sort of a situation, consideration is inadequate, right? Because you're already bound by public duty to do that. The best case is Colin versus Godfrey. So in this case, what happened was um, basically Godfrey was he was part of an action in court, right? And then Colin was sort of called by the court. I've used the word subpoena. Subpoena. So a subpoena is basically the court asking you to appear before the court, right? A subpoena is basically that, right? A court asking you to come before the court and give evidence, right? So if this person was asked to come now, Colin was asked to come before the court and give evidence. Then Godfrey had um he agreed to pay Collins for because he had obviously come before the court on several days, right, to give evidence. But of course, at the end of the day, he wasn't able to give evidence. The court did not require his evidence. And then Godfrey had he decided not to pay, right? And then Collins obviously filed action against him, saying I was supposed to be paid and all that. But then the court held that under public duty, when you're sent a subpoena, when you're asked to, in Sri Lanka, we call it giving notice, right? If you're given notice and if you're asked to come before the court, you have to come before the court, right? You're bound to do that. And if you're asked to come before the court, if you're already bound to come before the court, you can't accept some money to come before the court, and it's not enforceable. Why? You're anyways coming before the court, right? Now, for an example, if let's say some person was hiding and hiding from being arrested, and you decide to say that, okay, I'll pay you 50,000 if you come before the court, right? He has already been issued notice, right? Let's say someone is hiding. And then you say, okay, I'll give you 50,000 if you go before court. And then once he goes before he gets arrested, you decide not to pay. There is no contract there. Why? Because he was already given notice and he was given an arrest warrant. And just because he goes and surrenders, you don't have to necessarily pay him because he was already given an arrest warrant, right? So he was bound by public duty. But this exception, or sorry, this scenario, this particular law could change, right? This particular exception here could change under certain circumstances. The best example is when you go beyond your public duty. Now, this case is the best example. Glassbrook Bros versus Glamorgan County Council. So in this case, basically there was a breakout, and then as a result, they needed police officers to be stationed in that sort of premises to ensure that there is a level of protection or security in that premises, right? But then the police officer, the superintendent had said that the SP basically, he said that, sorry, the SI, my bad. The SI said that he would require an extra payment for the policeman to be stationed there, right? Let's say a policeman, he's sending policeman and the guy wanted the policeman to stay there. The manager wanted the policeman to stay there and ensure security, right? So because he wanted policeman to be stationed there, the SI asked for extra money, right? He had said, I want some extra money for this, right? But then later on, he had not paid, obviously. He refused to pay. He had obviously agreed to pay, but then he refused to pay later. Right? Then the court in this incident said that yes, by public duty, the police is expected to go and ensure security, protection of the people. But in this instance, they went beyond their public duty. Why? They're not normally expected to just go there and ensure that things are okay. But the manager had requested for these people to remain there, to be stationed in these premises, to stay there, right? When you ask the police officers to stay there, that is beyond their public duty. So because of that, they can expect an additional payment, right? So because of that, the consideration became valid, right? Is that clear? Any questions about that particular exception? Any questions? Anything? No? Right? Yeah. Sorry. Any questions, guys? Okay, I'll take that as a no. Yeah. Oh, thanks, Colin. Yeah. So moving forward, so the next exception is um, where a party has waived their right to sue. Now here, this is more of a situation where you consider it to be a valid consideration, right? So now I think explaining this with the case would help. So in a case, right, let's say there's two parties, A and B, right? So A is a bank, right? Let's say A is a bank, right? And B is a party that had taken a certain amount of debt. They had asked for a loan and they had taken money, right? Let's say the value was 10 million. Now 10 million was given without a security. Security in the sense, normally when a bank gives a loan, right? I'm sure you all are aware of this. When a bank gives a huge amount, let's say something like 10 million, they normally keep something as security. So let's say a land or anything for that matter, a land, a house, an apartment, a vehicle or something, you can keep it as a security. But this particular debt was not provided with a security. So because of that, B promised that he would give a certain amount of goods to the bank for the amount he had not paid. Now he had taken a loan and he had not basically paid it on time. So because this loan was not given a security as well, the bank had obviously the power to sue, right? They could have gone to court and asked for the money, but they didn't, and because of that, B had promised to give them goods, right? So that's the agreement, right? The bank will not sue B for not paying money if B gives them goods, right? That's the agreement. That's the contract, right? But then later B didn't obviously supply the goods that he had promised, right? Then obviously the bank went to court, and the court held that by the bank not going to court, right? By them not suing B for for his failure to pay the loan that he had taken, that is sufficient forbearance. So forbearance is basically one party losing out, right? Or one party compromising, right? So that compromise itself is a consideration, right? It's valid consideration because they decided not to sue. Not suing itself is consideration, right? So they would get goods for not suing, right? See the two sides of the contract, right? They promised to so one B promised to give goods if A the bank did not sue, right? So there's consideration. Both parties get benefits. B will not have to go for an action. I mean, B will not have to appear in an action, and A would receive goods in security, right? So both parties are happy, right? At the end of the day, what happens with consideration is both parties are happy, right? At the same time, right? When a contract is formed through consideration, right? Um, then the next exception is a contractual duty. Now, what I mean by contractual duty here is if a party is, again, similar to the public duty idea, if a party is, let's say, bound by a contract to do something, and if you do that same thing again, like let's say he's already bound by a contract to do it, and then then another party comes and says you do the same thing, right? let's say for an example, if A was asked, if A was asked to, let's say, deliver a certain amount of goods. Let's say A was like a pizza delivery guy, right? Let's say he was in Moratuwa, right? Now he was supposed to deliver goods, deliver pizza to Ratmalan, right? That was his first order. So he was under that contract. He had to deliver goods there, right? And then there was another order, the second order, right? Again, the second order was also on his way to Ratmalan, right? Now, the second order, it's part of the same, he's already going to Ratmalan. So second order is also in Ratmalan. So he can, if it's the same house, while giving the first order of pizza, he can give the second order of pizza as well. So he can't ask for an additional pay for the second one because anyways he was going to that house, right? Anyways, he was bound by the first contract to go to that house. So he can't necessarily ask for a second payment because he was anyways going to that house, right? That's the basic idea. So if you are bound by a contract to do something, you can't necessarily ask for an additional payment for doing the same thing that you're bound by the first contract to do, right? Now, if you ask to, like I said, if you ask to go to Ratmalana, you're bound by the first contract. And second contract also, you're expected to go there. Now, just by fulfilling the first contract, you're anyways going to Ratmalan. So you can't take an additional payment for the second contract because you're anyways bound by the first contract to go to Ratmalan, right? So that's the idea, right? Any questions? So that's the basic idea of this. So in this particular case, I'll do these two cases. So these two cases are contradictory, right? It's two different scenarios also. So just go through this. These very important questions. There are a lot of instances where questions like this could come about. And I think even for discharge, there are very similar cases. So just while going through this, just keep that in mind as well. Like for discharge, when you do it, you all will come across these cases, right? So now there was a ship, right? I'm doing the first case now, Stilk versus Myrick. So in this case, what happened was, um, there was a ship that was traveling from Baltics to London, right? And while the ship was obviously on voyage, two of the crew members had left the ship, right? And then each crew member, according to their contracts, were expected to be paid £5 per month, right? And then the captain at the time decided that, or he made a promise that he would pay the remaining crew. Let's say there were 10 members and 2 left. The 8 remaining members would be given equal shares of the salary of the 2. Right? So 2 people would be £10, right? That would be divided equally among the 8 people. So that was the promise made, but he obviously decided not to pay, right? Then when they returned to London, he didn't pay. He didn't pay the additional amount. He paid the normal salary. He didn't pay this additional agreement that was made. So the court said that the sailors were anyways bound to sail back to London, right, by the initial contract, and to meet emergencies along the way as well through the contract, right? So because of this reason, right, the captain, there was no valid consideration why it was not additional, right? It was just they are doing what they're supposed to do according to the first contract, right? And just because they were promised an additional payment doesn't mean it's a valid consideration. Why? Because they're anyways doing that under the first contract, right? So because of that, the consideration is not valid, and therefore that contract is not enforceable. Right? The first contract was, but not the second contract. Right? A very similar case. Again, a ship with 37 crew members. Out of the 37, 17 had left. Now, because of this, the ship was left in a very dangerous condition. Now, according to the earlier contract, in this scenario, in Hartley versus Ponsonby, so in this case, there was a dangerous condition that was not part of, obviously now when there's not enough crew members, it's dangerous, right? You need a certain amount of members to obviously take a ship forward. But then if you've lost that, right? If you've lost the optimum amount you need, there's obviously a danger of the ship not being able to reach its destination, right? So now there is a dangerous condition. Now this dangerous condition was not promised to, right? Let's say out of 37, 17 left now. So these 20 crew members were not promised or were not informed that they would be facing a dangerous situation like this, right? Because if they fail in obviously, let's say steering the ship properly, their lives are also in danger, right? So it's a very dangerous scenario. So this dangerous scenario is not promised in the first contract. So because of this, the captain, to sort of, I guess, to motivate and persuade them, he promised an extra wage, right? Which of course, once they returned to UK, he didn't pay. The court said in this condition, since this was a dangerous condition, that was very much over their normal duty. Now, according to their normal duty, they would be, let's say, they would not be working under such dangerous circumstances, right? When 17 out of 37 leave, you have only 20 working a workload worth of 37 people. One person has to do the job of two, right? So that's over and above their normal duty. So when that sort of a situation occurs, right, that is an additional contract, right? That contract is valid. Why? Because that's over and above their normal duty, right? So though they are bound by the normal contract to reach the destination, they were not bound by the contract to reach the destination under dangerous circumstances. So because of that, there was an additional contract created, and that was valid because there was an additional wage promise. So because of that, the wages were valid, right? Again, is that clear, guys? So I think that's again a bit of a confusing part. If you all have any questions, again, like drop it on the chat box, right? Then the existing contractual duty owed to a third party. Now, in this scenario as well, what happens is, let's say you promise someone to do, let's say you promise to do something for someone, right? But then in the end, you promise to do something for someone while being bound to do it for another, right? In that sort of a scenario, it's considered as good consideration, or it's valid consideration. Now this might be a bit confusing. I'll try and like simplify it as much as possible. So what happens here is, let's say three parties, A, B, and C, right? Now A was supposed to supply, let's say something like, now this case has coal, right? So A was supposed to supply coal to B, right? But then B decided to sell that coal that was supposed to be supplied to C, right? To C, right? Now, let's say B purchased 100,000 worth coal from A. So now A is supposed to deliver it to B. But before he had delivered it, B had sold that amount that he bought to C, right? To C. Now he had sold that amount to C, right? So now C is the rightful owner. So then A is supposed to now deliver it to C, right? Now, though he was bound to deliver it to B, now he is bound to deliver it to C. But there is still good consideration there. Why? Because again, though though B was the third party, right? Though B was the third party, you know, when it's sold to C, A is delivering it to C, right? So A and C are the parties. But why is he delivering it to C? Because A had an agreement with B initially that he would deliver coal, right? So B is now the third party. He's not part of this contract with A and C. But because of the contractual duty that was held on B, like basically the duty to supply it to B, he supplies it to C. But still, it's considered as consideration, though he was bound by an initial agreement, right? Though, so for an example, now in that, you know, in that scenario, if B hadn't asked for coal, A wouldn't have anyway supplied it, right? So B is there. B is a party. right? But now A is supplying this to C in the end, right? It's going through B to C. But B is a third party, right? But if B's contractual duty didn't exist, the supply between A and C wouldn't happen, right? The supply between A and C wouldn't happen if B hadn't asked for this, right? So by fulfilling B's contractual duty, A is actually providing valuable or consideration, a valid consideration to C. So that is what happened. That's what's happening in this case as well. So though he's fulfilling a contractual duty towards B, he's actually giving the consideration, or the person who's benefiting is C, right? So because of that, it's a valid consideration. Though it is fulfilled by a contractual duty to another person. Got it? I think that must have been a bit confusing. Is that clear, guys? Must have been a bit confusing. Okay. Yeah, I'll explain that again. Sorry. I think I did confuse it a bit. Sorry. I'll explain it again, right? So simply what happens here is, okay. So now A and B come into a contract, okay? Saying that A will supply coal to B, right? Okay, now that's the initial contract. Now A is anyways bound to deliver coal to B, right? Okay. So then B decides to provide this coal that he was supposed to get to C, right? Now C, he sells it basically. Like let's say he had bought 100,000 worth coal. C pays him 100,000 and he gives the ownership of the coal, right? Now A in this agreement is contractually bound to provide coal to B, right? Now contractually bound to provide coal to B. But the benefit is gained by C, right? So the benefit is gained by C. Though he was bound to sell it, or though he was bound to supply it to B, the benefit is gained by C, right? So now B in this instance is the third part, right? Exactly. B is like a middleman, right? B is like a middleman. He's like a third party. He's not part of the final contract. Right? The final contract is between A and C, right? You're supplying something to C in the end, right? But based on the duty that you were bound to supply to B, right? I mean, the initial agreement, you were bound to supply to B, but by supplying it, by fulfilling that contract, you're supplying it to C, right? So B is a middleman. He's a third party to the contract, but you're still supplying it to C, or it's supplied for the benefit of C due to a contract that existed between A and B, right? But still, the benefit gained by C in this instance is considered as consideration, right? So that's the idea. I hope that's clear now. So he's like a middleman, basically. He's like a third party. Must have been a bit confusing. Yeah. Okay, nice. If you all have any questions, guys, like just say it on the chat box, right? Some parts are a bit confusing, like in this particular segment of the lesson. So yeah. Okay, then part payments. Now, part payments is also a bit of a confusing part. But like I'll try my best to like simplify it a bit. Sometimes it gets a bit confusing. So under part payment, so in English law, part payment is not considered as a good consideration, right? No, right? Let's say part payment in this instance is basically like, let's say you agree to pay 1 million and then you later only pay 500,000. You can't expect that 500,000 to be considered as 1 million, right? Obvious, right? When you're expected to give, let's say, 1 million, you can't pay 500,000 and tell him to give you the land, right? Let's say it was a land, right? You're expected to pay 100,000 to get 1 million to get a land, right? And you pay 500,000 and you ask for the land. That's not right. I mean, the agreement was 1 million. So a part payment cannot be considered as full consideration, right? So this was established in in the Pinners case. So in the Pinners case is basically like the main judgment, the main case that we follow under part payments, right? So this is in this case, right? In this case in particular, right? In this case in particular, what happened is Pinner basically was expecting 8 sterling pounds, I think 8 sterling pounds from Cole, and then Cole had not paid 8. Instead, he had paid £5 on an earlier date, right? Let's say before, like lay down like a small timeline. Let's say A and B again, right? So A had obtained a loan from B, right? Now, he had obtained the loan on 1st of January 2025. He was expected to pay on the 1st of June 2025. But, but B had said that you can pay, let's say the loan was 1 lakh. B had said, okay, you pay me 75,000 on the 1st of May as a full payment. Now B said that, okay? So if B had said that, what it means is, though, like normally, the normal rule here is that if you pay a less, now 75,000 is not 1 lakh, right? 75,000 is not 1 lakh. The debt was, or the loan was 1 lakh, right? But if the creditor, if the person who basically gave you the loan, if he says you can pay this amount a bit earlier, let's say on the 1st of May instead of 1st of June, he says, okay, pay me for on the 1st of May 75,000. Let's say he wants 75,000 on the 1st of May. He goes and says that. And then if A goes and pays that amount on the 1st of May, that means it's a full consideration, right? Though it's not the full amount that was initially agreed, it's a new consideration that should be agreed to as the full payment, right? Why? Because there's an additional benefit, right? You initially agreed to pay on the 1st of June, but you pay a month earlier. That's an additional benefit, right? Let's say suddenly you needed some money. But again, in this case, this further benefit should come from the promisor, basically, or basically the person, the creditor, basically. Sorry, not promisor, the creditor, the person who basically gave you the money. If he had requested you to pay it earlier and pay a lesser amount earlier, that would be a valid consideration, right? Because it's a new consideration, right? But again, remember, this has to be upon his request, right? If not, a lesser payment is not the full payment, right? That's the normal rule. The normal rule is a lesser payment is not a full payment unless at the creditor's request, you give it earlier on an earlier date and a lower payment, right? Or you could give something else. Let's say you had promised 1 million. Instead of 1 million, you decide to give your car for the land, right? Now that's an additional benefit, right? But again, the creditor has to agree to it, right? It should be upon his request, right? So the additional benefit, you can't just go and give something else and get it, right? Right. Then this was further clarified in this case as well, Forks versus beer. So in this case also again, a person failed to pay, right? And the loan was £2,000. And then he agreed to pay the 2,000 pounds with an initial payment of 500 £500 and the rest in 6 months installments, right? But at the same time, by way of law, this person was eligible for interest, right? Which was worth £300. Now, though there was an agreement made to pay this in installments, the full consideration should have been with interest, right? So the full consideration was not made, right? And the payment was not made on an earlier date either. It was made later. So the payment was not made on an earlier date. So there was no independent benefit or like an additional benefit or an added benefit given to the person, right? It's just a normal benefit. It's not it's not the benefit he expected either, right? So he expected, let's say, two 2090 pounds by a certain date. You don't get it. You file action. You go for a different plan, and you get only 2000 without interest. Again, it's less than what he expected, right? So again, it's a part payment. So this part payment again cannot be considered as full consideration, right? So that's the important thing there. Is that part clear? Before we move into the exceptions, I just wanted to clarify that. Yes. Okay. Yeah. Right. Then to this rule, now part payments cannot be accepted, no? But to this rule, there's also a few exceptions, right? The first exception is that a part payment by a third party. Now, if the part payment is made by the third party with the creditor agreeing that he would release the obligation, right? Then that is considered as valid consideration. Now, for an example, this the case that I've given here, right? The temper case, right? In this case, what happened was the father of the person who had obtained the loan went and spoke to the creditor, the person who gave the loan, and he had said, "I'll pay you a certain amount, which is obviously less than the amount. Let's say he had obtained 1 lakh, I'll pay you 80,000, but you have to consider this as the full amount." Then he had said, okay, he had agreed. So what happened here was basically he had sent a letter. He had said, "I'll only pay you 80,000." And he had sent a check. He had sent a check of 80,000 saying, okay, you accept this as the payment. And then this guy had gone and encashed it. He had cashed it. He had basically gotten the cash out of the check. Right? So when you cash a check, that means you basically accepted that, right? So if you had wanted more, you wouldn't cash that check, right? You would have said, I want more than this, I want the full payment. Please give that, right? He didn't do that. Because of that, the court said implicitly he agreed to this promise by cashing the check. So because of that, he was not entitled to the full amount, right? Again, this payment was by a third party, right? So when it's made by a third party with the agreement of the creditor, then it can be considered as full payment. Then you have something called composition agreements. So composition agreement is basically when, let's say, when one person has taken loans from a lot of people. Let's say, now for an example, Sri Lanka, right? We've taken loans from a lot of countries, right? But we together, like we agree with all those countries to only pay. Let's say Sri Lanka has taken, for an example, let's say I won't name countries, but like let's say we have taken loans from A, B, and C countries, right? We've taken 100 million from A, 200 million from B, and 300 million from C. That's 600 million, right? Now, we sign an agreement saying that we would pay 400 million for all these loans, right? Which is a reduced amount from all of these people, right? So that's called a composition agreement, where you agree with all the creditors that you would pay a lesser percentage. You would pay, let's say, 80% of what the loan you take, like whatever the loan you take. If it's 100, you pay 80. If it's 200, you pay 160. If it's 300, you pay 240, right? So likewise, you agree, right? So if you come to an agreement like that, one creditor, one country, let's say from ABC, B, let's say country B, they can't sue us for not paying the full amount. Why? Because the others have agreed to take that percentage, right? So if the others have agreed to take that percentage, you can't go and file action by yourself, which would amount to fraud on the others, right? Because the others have accepted that, and you also accepted that. And you can't necessarily just, as a single country, as a single creditor, you can't go and file for action. So this was found in the case of Wood versus Roberts. So this principle. And then coming into promissory estoppel. Promissory estoppel, this is like again a very key, it's a key concept of contract law. So what this basically means is when someone makes a promise to another person and that person acts on that promise. If you were given a promise, and if you were given, let's say, you asked to, let's say, clean a garden, right? And you were told, like, let's say you were said, okay, go and clean my garden, I'll pay you this much, right? Now, even if there's no consideration, let's say, even if there's no consideration, let's say you say, okay, I'll give you something, right? Something like that. Let's say the consideration is vague or whatever. That doesn't necessarily allow, if you have gone and already done what's on your plate, right? Let's say what you're supposed to do. If you fulfill your promise, what's on your part, then that doesn't stop the promisor from going back on the promise. Basically, from saying I won't pay. You can't say I can't pay, right? That's a principle of contract, promissory estoppel, right? If you fulfilled your part in the promise, you can't just say, okay, if someone else has fulfilled their promise, you can't say, okay, that doesn't matter, and like I just said it or something like that. You can't just be vague, right? So it stops a promisor from going back on his promise, right? Because you promise to do something, you promise, let's say, consideration or whatever. If someone else has done it, then you have to fulfill the promise, even if there's no consideration, right? Even if there's no consideration given, you still have to fulfill that promise. And that's called promissory estoppel. So promissory estoppel, there's two important cases. One is the Hughes case. So in this case, what happened was, so a person was given 6 months notice to a tenant was given 6 months notice to uh, let's say, repair a property that he was basically, that he had leased out, right? If not, his lease will be forfeited, right? Or basically cancelled, right? So the landlord had come into or he had basically given notice, right? That within 6 months you have to repair the house, right? And then later, now this happened in October, and then in November, the landlord and this tenant came into negotiations to sell this property, basically to buy it. Now the tenant wanted to buy the property, but then in December, these negotiations ended, right? They couldn't come to an agreement, and the negotiations ended. Then after 6 months from October, right? After 6 months from October, that's in April, uh, the landlord had asked the tenant to leave, right? Because 6 months had passed since he gave notice. But the court held that by the landlord's conduct, now the landlord had gotten into negotiation, right? When you get into negotiations, it was reasonable for the tenant to uh, make an implication that he didn't expect this repair to happen, and that initial promise did not stand, right? So because of that, the court said that since the landlord's conduct, especially with regards to negotiations, showed that the landlord didn't want to necessarily enforce the notice, the 6 months period once again began after the negotiations had come to a close. So the negotiations came to a close in December, so 6 months will start again in December, right? So that will give him time till June to do the repairs, right? So that's the idea, right? Now you had an initial promise, right? But then the actions say otherwise. When the actions say otherwise, then there is reasonable, like you have reasonable, you can make a reasonable implication that he didn't want to enforce this notice, right? So that's the idea, right? And then in the high trees case, now this is also sort of an important case. In this case, what happened was two parties basically came into a tenancy agreement, and sorry, not tenancy agreement, 99-year lease. So basically similar, right? On a lease agreement, where the annual rent was around £2,500, right? But then in 1939, this was formed in 1937, and in 1939, the Second World War broke out, right? And as a result, now the the tenants couldn't basically fulfill the high rent that they were given, right? So they asked for a reduction in the rent, right? Um, so this reduction was granted, but then after the war ended in 1945, uh, the landlords had asked for, now the war ended somewhere in May, right? So once the war ended, they had asked for the normal payment according to the original agreement from June onwards for the last 2 quarters. So the court said that they were entitled to recover this money, right? But at the same time, they established something called the High Tree Doctrine. Now, in this, what they said was, now, because they agreed to only claim a lower amount, right, during the war period, that was a separate promise, right? That was a separate agreement, separate contract, right? Because of that, after the war, you can't necessarily ask for a payment of arrears during the war period. Why? Because you came into a different contract, and that was a different promise. And in that sort of a scenario, uh, basically the promisee, the person who basically the tenant in this case, can use that promise for his defense if he had not paid the entire consideration. Right? He had paid a lower consideration. Now the initial consideration was 2,500, right? But he had paid a lower amount during the war period, and you can't claim for that lower amount because a different promise was made. So if an action is instituted, the promisee or the person, the tenant here, can use that promise as a defense. He can say, we came into an agreement that I would pay a lesser amount during the war period. So because of that, you can't ask for arrears during that. Right? Though the initial agreement says that this is a consideration, though it was a part payment during that period, you can't ask for arrears. Right? So that's the high trees doctrine, where if you agreed that you would pay a lower amount, that agreement should stand. Right? Though it's part payment, that agreement should stand. Right? That's the idea. So part payment can be made, can be enforceable, though, because there was a separate agreement, because there was a separate promise. Yeah, is that part clear? Part payments. Any questions? Anything? Okay. Yeah. Right. I'll continue then. So this is the last rule basically. Consideration must be sufficient. So again, what I mean by sufficient is, again, it doesn't necessarily have to be equal, but it should possess a value. So a monetary or an economic value, right? So the best example, like I said, doesn't have to be equal, right? Best example is the Chapel Co. Limited versus Nestle Co. Limited case. So in this case, basically, Nestle decided to sell few records if a customer basically gave 3 wrappers of their chocolate bars, right? If someone comes and gives the company 3 wrappers of their chocolate bars, they would they would basically give a record or some sort of like a musical record. It was called Rocking Shoes in return, right? Um, so though rappers are not really like, there's no value to it, right? In a normal context, even the company would throw it away, right? But in this case especially, uh, in these circumstances, the rappers had a value, right? And the rappers were valued considerably. Though it does not necessarily have have an economic value, it still has a value in this contract, right? Because that's what the party wanted, and the party expected to get rappers, and for which he would give a musical record, right? So that was the agreement, right? So that's the important part there, right? So now even rappers, again, could be considered anything, right? Even let's say let's say some sort of like not only wrappers, anything that does not necessarily have an economic value, right? Let's say leaves or something. Someone says, okay, bring 5 leaves, I'll give you that. It's consideration in that context. In that context only, though it's not of value to others, for that contracting part, it could be of value, right? Yeah. Then the next case is Thomas versus Thomas. So in this case, what happened was basically um, um, a person had left his house for his wife to be given to his wife to live for the rest of her life, right? Uh, but this was not like, though he had promised this, this was not part of his last will. So it was not necessarily enforceable, right? Um, Nevertheless, this house that was obviously allocated for her was given to her at a monthly rent of 1 sterling pound, right, by the executor. Let's say executor is basically the person who executes the last will, right? So since this was not part of the last will, though this was a sort of an oral promise, they gave her this land or this house for 1 sterling pound, right? Now, 1 sterling pound is considered as a peppercorn rent at that time. It's basically a very sort of a minute value. Right? It's not of value, right? 1 sterling pound for a house, right? It's not the commercial value of this property. However, the court held that by paying rent, though it is not equivalent to the economic value or the commercial value of this property, it is still consideration, and therefore there was a enforceable contract, right? Yeah, is that part clear? Any questions there? Okay. So yeah, so that's basically it for the rules. Those are the 5 main rules. So firstly, that the consideration should flow from the promisee, right? That was that was the first rule. Then second one was that consideration cannot be in the past. Then the consideration does not necessarily have to be adequate, and then the consideration does not have to be sufficient, right? So those are basically the rules, right? Then we come in finally to something called the practical benefit test. Now, I just added this as like an additional case. This will be discussed in the future as well, but I just wanted to mention it here as well. So in this case, what happened was no, so Roffey brothers was like they were builders, right? So they had contracted a building agreement where they decided to construct a certain house or an apartment complex, right? For like a few flats, basically, right? And they had basically given a subcontract to a person called Williams, who was a carpenter, to finish this work, right? So according to their initial contract as a builder, the building contract, they were bound to complete the work by a certain date, right? Now, since they were far behind schedule, they had told William that they would pay a bonus amount, or basically pay a bonus, make a bonus payment if he had finished work on time, right? If he had finished work on time. So then Williams had agreed to this, and he had somehow finished the work on time, right? But then obviously the company didn't pay, right? So then he sued the company, and then the court in this instance said that the promisor, though this was like part of the normal contract, he did basically what he was supposed to do, right? He was anyway supposed to finish construction, or he was supposed to do his part. But they were running out of time, so they promised an additional payment. Now, by finishing the work before the deadline, the promisor gained a practical benefit. Why? Because if he had not finished the work on time, if he had not completed by the deadline, he would have to ideally pay a certain fine uh, for delay, right? So he gained a practical benefit by Williams working on time. So because of that benefit, Williams was to be paid that extra amount. So that was considering, right? Because of the practical benefit. So when it comes to consideration, again, though it's the same contract, though it's part of the same contractual duty, though he's fulfilling the same contract, if there is a practical benefit to the promisor, then again, that could be considered as consideration, right? Yeah, so that's basically it. Any questions, guys? Okay, no questions. Right. So that's basically it for contract for today. I think next we have Roman law. So tomorrow we'll complete the rest. I think we have intention to form legal relations. Then Abdullah will do terms as well tomorrow. And I'll also be doing initiating factors tomorrow if you all can come, right? And we'll be doing all of that tomorrow, and then afterwards we'll be doing discharge. So we'll be covering that. And yeah, that's basically contract. If you all have any, like, if we can, we'll go through remedies as well. If we have enough time, right? But for now, we'll try and finish vitiating factors tomorrow, along with the stuff we couldn't cover today. But I think we're starting at 2, if I'm not mistaken. So yeah, that's it. That's basically it from me. Any questions? Again, I'll just ask again. There's not many in the meeting right now, but if you all have any questions, it's fine if you all aren't able to send it now. Even if you all watch the recording, if you all have questions while listening to the recording, again, just drop me a message. And if you all need any support with regards to consideration, again, just drop any of us a message. Like whatever was discussed today, just drop any of us a message. Isuru, myself, and even Abdullah, right? If you all have anything, just drop us a message. So that's basically it for now. Just join in for Roman law. I think that's at 2.